Legal collection strategy. Boosting recoveries with governance. Discipline v. Smart escalation. Good day, everyone. Today I want to talk about something that sounds scary but is actually very practical: legal collections. This isn't about being aggressive. It's about being smart, disciplined, and strategic, so we recover more money, spend less, and avoid unnecessary headaches. Think of this as turning collections from reaction mode into a well-governed system. Slide 2. Why this matters. Why legal collections must be strategic. Let's start with the obvious question: why should we even care? Collections directly affect our cash flow. Every peso recovered is money we can use again. But here's the problem: if we escalate cases poorly, too early or too late, we waste money on legal fees and get little back. Worse, if collections are done badly, we risk complaints, bad reputation, or regulatory issues. Since our resources are limited, we can't shout louder. We have to think smarter. Collections is like chess, not boxing. Slide 3. Current realities. Current constraints we must design around. Now, let's be honest about our reality. We don't have in-house skip tracing yet. We have one litigation lawyer. We're handling a lot of old, disputed accounts. So the question isn't what's ideal. The real question is, how do we win with what we have? That's why this framework exists. Slide 4. Strategic principles. Our legal collections principles. These are our ground rules. First, collections before litigation. Court is the last card, not the first. Second, right case, right channel. Not all accounts deserve the same effort. Third, legal pressure early, court action late. Sometimes a lawyer letter works better than a lawsuit. Fourth, cost-benefit discipline. If we spend 100 pesos to recover 50 pesos, that's not strategy, that's emotion. Finally, our in-house lawyer is a strategist, not a volume processor. Slide 5. Account segmentation. All accounts must be classified first. Before we collect, we classify. We ask simple questions. How big is the balance? Are the documents complete? Is the borrower reachable? Are there assets? How old is the account? This is like going to the doctor. You don't give medicine before diagnosing the patient. Slide 6. Collections decision tree. 3 clear paths. Once classified, every account goes into only one of 3 paths. Internal collections. Legal pre-litigation. Or litigation with external counsel. No shortcuts. No jumping straight to court just because we're annoyed. No classification. No escalation. Slide 7. Path 1. Internal collections. When internal collections are enough. This is the friendly but firm path. We use this when the balance is manageable, the borrower answers calls, and documents are complete. Here, deadlines matter. Payment plans matter. Clear consequences matter. Think of this as saying, we trust you, but we're watching the clock. Slide 8. Path 2. Legal PRE litigation. Where legal adds the most value. This is the sweet spot of the framework. At this stage, legal steps in, not to sue yet, but to signal seriousness. Lawyer-reviewed demand letters. Final notices to sue. Negotiations. Compromise agreements. Many borrowers pay here once they realize this is no longer just collections, it's legal. Slide 9. Parameters for filing cases. Cases are filed only if all are met. We don't file cases based on feelings. We file based on rules. Documents must be complete. Borrower must be identifiable. Recovery must be at least 3 times the legal cost or have strategic value. Negotiations must be exhausted. And legal must approve. Court is expensive. We only go when it makes sense. Slide 10. Cases we do not file. What we avoid. Equally important, what we don't do. We don't file low value, no asset cases. We don't chase ghosts. We don't litigate with weak documents. And we never file cases just because we're angry. Litigation is leverage, not punishment. Slide 11. Collection agencies. When to use them. Collection agencies have a role, but it's limited. We use them when borrowers disappear and internal efforts fail. They work on contingency, must follow ethical rules, and cannot pretend to be lawyers. They support the strategy, they don't replace legal. Slide 12. In-house versus external counsel. Clear role separation. Our in-house lawyer designs the game plan. External counsel executes court appearances, filings, geographic reach. If everyone does everything, no one is accountable. Clear roles equals better results. Slide 13. KPIs v. benchmarks. How we measure success. What gets measured gets managed. We track recovery rates, especially pre-litigation success. We watch cost per peso recovered. We track settlement rates. And we review external counsel ROI quarterly. If it doesn't improve recovery, we rethink it. Slide 14. People v. governance. Mentoring v. safeguards. This framework is not just about money, it's about people and ethics. We mentor. We review cases together. Sensitive actions need dual control, because strong systems matter more than strong personalities. Slide 15. Next 90 days. Action plan. Erase what we do immediately. Adopt the legal collections matrix. Standardize templates. Formalize filing approvals. Create a panel of external counsel. And meet monthly to review progress. Simple steps. Big impact. Slide 16. The end goal. What success looks like. At the end of the day, success looks like this. Higher recoveries. Fewer cases. Lower costs. Strong governance. And a confident, trained legal collections team. That's how we scale with discipline, not drama. Thank you.